Hi, today we'll be seeing what are the rights of a banker. Banker's rights. The first is right of general lien. The second one is right of set off. The third one is Clayton's rule. According to that, what is the bank's right of appropriation? So that is Clayton's case that is explained. And the fourth one is right to charge interest, incidental charges. The last one is the slightest of the rules, which is limit on which the payment of drafts have to be done. That is called period of limitation. So we will see these first four in detail, and the last one will touch upon that. What is right of general lien for the banker's rights? One of the important rights enjoyed by the banker is the right of general lien. Lien means, as you are aware of that, lien means what? The right of the banker to retain the goods and securities owned by the customer until the debt due to him is repaid. So this is not to sell it, but only to hold it. General lien is hold it, with the intention to be retained by him as security. A very famous example is there for that. Similar to a tailor has the right to retain the clothes made by him for his customer until his tailoring charges are paid. This is very famously quoted on the general lien. A general lien, on the other hand, is applicable in respect of all amounts due from the customer to the banker. So this is specified under Section 171 of the Indian Contract Act 1872. What are the features of this general lien? The goods and the securities have been entrusted to banker as a trustee and he cannot sell it. Point one. Point two. It's a contract exists between the customer and the banker. So these are the 2 points which you need to understand on the general lien. Then what are the exceptions on this general lien? In case of safe custody of deposits with the banker for safe custody purpose, he entrusts them to the banker as a bailee. So the relationship between the banker and the customer is bailor and bailee. So with the purpose to ensure their safety from theft, fire, etc. So second point, a document is deposited for specific purpose. If a customer sends a bill of exchange or any other document with specific instruction to utilize its proceeds for any specific purpose, for example, if he directs the banker to collect the proceeds of bill of exchange on its maturity and utilize the same for honoring another bill of exchange on his behalf, the amount so realized will not be subject to right of general lien. Similarly, if a customer hands over to the banker some shares with the instruction to sell them at or above certain price, and the same are lying unsold with the banker cannot exercise his right of lien on the same. So I hope these exceptions are very clear. So when does a general lien becomes a particular lien? The syndicate bank furnished a bank guarantee of rupees 90,000 on behalf of its customer. The customer deposited with it as security 2 fixed deposits receipts duly discharged. Discharged meaning on the back of the fixed deposit he has signed and then given, with a covering letter stating that the said deposits would remain with the bank so long on any amount was due to the bank from the customer. Bank made an entry on the reverse of receipt as lien to bank guarantee, that specific number. Bank guarantee number was mentioned. When the bank guarantee was discharged, the bank claimed its right of general lien on fixed deposit receipt, which was opposed on the ground that the entry on the reverse of the letter resulted in the right of a particular lien, that is only in respect of the bank guarantee. So the Delhi High Court rejected the claim of the bank and held that the letter of the customer was on the usual printed format only, but the words written by the officer of the bank on the reverse of the deposit tells us what was in the minds of both the parties at the time of entering into this agreement. Thus, the written word will prevail over the printed word, and hence this was considered that the fixed deposit should be for that bank guarantee only and not for any other claim by the bank. Then banker possesses right of set off, meaning what? The banker's right of lien extends over goods and securities handed over to the banker. Money deposited in the bank and the credit balance in the accounts do not fall in the category of goods and securities. The banker may therefore exercise the right of set off, rather the right of lien in respect of money deposited with him. So the balance lying in the account can be utilized in case any claim arises later. Second one is right of set off, meaning what? The right of set off is a statutory right. The statutory right it is, which enables the banker to take into account a debt owned by the customer. The example, A has taken an overdraft from his banker to the extent of 5,000 and he has a credit balance of 2,000 in his savings bank account. The banker can combine both of these accounts and claim the remainder amount of 3,000 only from the customer. The right of set off can be exercised by the banker if there is no agreement expressly or implied contrary to this right. And after a notice is served on the customer intimating the bank about the bank's intention to exercise the right of set off. To be on the safer side, the banker takes a letter of set off from the customer authorizing the banker to exercise the right of set off without giving him any notice. The right of set off can be exercised subject to the fulfillment of the following conditions. What are they? Point number 1. Accounts must be in the same name and in the same right. Meaning, if it is a single name, the savings account also should be in borrower account and the savings account should be in the single name. Point number 2. The right can be exercised in respect of debts due. Point number 3. The amount of debts must be certain. Certain meaning it must be exact amount. It cannot be either this or that. Then the fourth point is the right may be exercised in the absence of an agreement to the contrary. There should not be any contrary agreement. Point number 5. Banker may exercise this right at its own discretion. Point number 6. Banker has right to exercise this right before the garnishee order is made effective. So if garnishee order comes, then banker loses the right of set off. There was some famous case, the third one which we thought we will discuss, Clayton's case. It's a very, very famous in banking circle and finance circle about Clayton's case. What is that Clayton's case? This happened in 1816. So a firm of bankers known as Devians, Daves and Noble & Co. had 5 partners. Devians, the senior partner, died and the surviving partners carried on the business of banking under the same name. The executors of the deceased partner objected to the continuance of the name Devians in the firm's name. After a year, the firm became bankrupt and various classes of creditors of the firm placed their claims against the estate of Devians, the deceased partner. Young Clayton was one of those creditors who continued to deal with the surviving partners by making payments to and receiving payments from the firm. At the time of death of Devians, Clayton's balance was 1,713. During the next few days, he withdrew several times and thus the balance has been reduced to 453. Thereafter, surviving partners paid more than 1,713 to him and subsequently his deposits with the firm largely exceeded the amounts withdrawn by him and thus his credit balance at the time of bankruptcy of the firm was larger than the amount which was due to him at the time of death of Devians. Clayton claimed that amount of 453 as reduced by the dividend on this amount which he received from the liquidator of the firm. was due to him from the estate of the deceased partner. His contention was 1. The withdrawals from the account after the death of the partner were paid out of the deposits made in the same period when he was alive. Second claim is the credit balance standing at the time of partner's death was recoverable from the deceased partner's assets and not from their legal heirs. These arguments were not accepted by the court and Clayton's claim was rejected. William Grant observed the general rule of appropriation as follows. So, the rule derived from Clayton's case is of great practical significance to the bankers. In case of death, retirement, or insolvency of a partner of a firm, the then existing debt due from the firm is adjusted or set off by subsequent credit made into the account. So this is the general trend that has been followed after this Clayton's case is finalized. So the right of set off for the banker exists in case of death of one of the partners. So the fourth one is right to charge incidental and interest by the banker. As a creditor, a banker has the implied right to charge the interest on advances granted to the customer. The last part which we said we will just touch upon is period of limitation. Deposits are repayable on demand made by the customer. Under Article 22, Part 2 of the Limitations Act 1963, the period of limitations for the refund of bank deposits is 3 years. With effect from that, the date of a customer makes a demand for his money. So within these 3 years, the banker, the period of limitation is 3 years for the settlement of this money when the claim comes to the bank. So hope the rights of the banker is very clear from this video. There were 5 rights which have been discussed in this, and the main important thing is Clayton's case, how it was argued, and then what is the application after the case for all the bankers and the customers. Thank you very much. In case you have any doubts, any clarification required, please put it in the description column, and also circulate it to your friends for understanding of these rights of the bankers in the financial circle. Thank you very much. Bye-bye.